begin. Just one announcement before we start today. We're starting regular office hours starting this evening. They're from 6 p.m. until 8 p.m. on Zoom. The number for the Zoom call is in the syllabus. There's nothing that you need to do. If you want to come to office hours, you can sign in at any time and leave at any time. In other words, you don't have to be there at 6. You can sign in whenever you want to. And you can come if you have questions for me, or you can come because they are outward in the room and you want to listen to whatever questions they have. And as with the makeup hours that I had on Friday, I will try to stay as long as there are people in the room. But if after a few minutes no one is signing in, then chances are I will sign out. Okay? Are there any questions for me before we begin about office hours? Okay. Chances are by the time we finish class today, we're going to catch up to all the cases that were assigned for last Thursday as well as today. And today's class is very important because what I want to offer you today is a structure that I've alluded to in the past, but that you can use to essentially cover every single case that we'll discuss in this topic. So, let's back up. I mentioned last week that there is only a single question that concerns us from now until the end of the subject matter. And the single question is very simple. It is, under what circumstances may a court exercise personal jurisdiction over a defendant consistent with the Constitution? That's the only question. Okay? And that question is actually very simple if you pretend for a moment that we are living in a universe that is controlled entirely by Prenoyer and there is nothing else. Okay? So let's you not pretend that's what it is right now. The world is controlled by a single case, it's Prenoyer, and the question we're trying to answer based on the information we have in Prenoyer is under what circumstances may a court exercise jurisdiction over defendant. What I want to suggest to you is that there are two kinds of defendants. Right? Under a Prenoyer regime, we know for an absolute fact it is fair for us to exercise jurisdiction over them. Right? What are those two kinds of defendants? And I'm not talking, let's forget for now the issue of property, environment, all of that. Simply think two kinds of defendants. Yes.
A citizen or someone that's in the territory of the state.
Okay, so we know for a fact it's either you're a citizen or you are in the territory of the state. So if we are living entirely in a Prenoyer universe, and I tried to sort of describe that doctrine in a very simplified way, I might do something like this. I might say, is defendant citizen? The answer is either yes or no, right? If you really want to simplify it to its core. Let's pretend for now the answer is yes. Okay? Now, just because the person is a citizen of that state doesn't necessarily mean, again, even if you stipulate to Prenoyer, that I'm done with the analysis. What other question must I ask myself? Even if I know for a fact this person is a citizen of Virginia, what must I satisfy myself? Next step. Yeah. I don't think I care about that at all. Because remember, if you're a citizen, you don't have to be within the state. You always assume to be in the state no matter where you go. There is some technical stuff I have to check, a box that I have to check before I can say, okay, we proceed with those. Yeah.
The proper service of the Constitution.
Exactly. Have you been given notice? And remember, Prenoyer talked about that itself, okay? Now, you may wonder yourself, well, what does that mean? How do I know whether notice is proper? You don't have to concern yourself about that now, because if you look at the syllabus very carefully, it's basically the last class we have in this topic. Okay? All right. So the answer again with notice is either yes or no. If the answer is yes, notice has been properly served. Do we agree that at least with respect to the citizen, I know I've checked all the boxes and I can exercise jurisdiction. Is that correct? Okay, so we know if it's yes, then I have jurisdiction. Supposing it is no, what's the answer? The person is a citizen, but I've screwed up the notice and the person hasn't been given notice. Do I have jurisdiction over that? I mean, it's not a trick question. No, I don't have jurisdiction over them. Maybe I can fix it, but let's just assume I don't fix it, right? So it means then I don't have jurisdiction over them. Very simple analysis based on Penoy. Now let's go back here. I said that the answer is yes, the person is a citizen. Supposing the answer is no, the person is not a citizen. What's the next question I should ask myself, again under a Penoy regime, for the analysis? Yes, sir.
Is he present in the form?
Yeah. Is the person present in the form? The answer again is either yes, the person is present, or no, they are not present. Supposing the answer is yes, the person is present, where do I go next in this chart? Once you understand that it's really a very simple analysis.
Have they been properly served?
Exactly, you always go back to notice, right? Okay, so the answer is yes. If you go, and I know this chart is very ugly, if the answer is yes here, then again you go back to jurisdiction. What about if the answer is no? I'm sorry, if the answer is yes, then you go back to notice, not necessarily here, I suppose, you do this, right? You simply go back to the notice analysis, right? Supposing the answer is no, that is, we've gone down to this chart and we say the person is not a citizen, and the person is not present in the state, right? That's basically all the cases that we're going to talk about today. So essentially, if you think about the chart that I keep bugging you about, you can begin to construct it, even though this may be sort of more complicated because you're adding facts and cases inside the box. The easiest way that you know you can get jurisdiction of a person is if they're a citizen. If they're a citizen, then you basically make sure you give them notice. But even if they're not a citizen, you can still get jurisdiction over them because they're present in the state. If they're present in the state, you give them notice, you have jurisdiction over them. But even if they're not present in the state and they don't have, you don't have jurisdiction over them, you may still have, and they're not present in the state, they're not a citizen, you may still have jurisdiction, because if you were living in a pure Penoy analysis, this chart would be over. Because the moment you say no to this, then all you have to do is go here. But we know that Penoy is not the sole controlling authority right now. So the question then is, how do we expand the chart? If the answer is no here, where do you go? So let's turn to international shoe, shall we? Can someone briefly describe for me, not the rule of international issue, but the facts of the case? Yeah.
So, I believe it's in Washington that International Shoe conducts business there. They don't have any buildings, they don't have any offices, but they do have sales representatives who sell products in Washington.
Okay.
Washington has a law about employee retirement benefits that they believe International Shoe has to pay.
Okay. And International Shoe, if you spin, now let me ask you this. Was International Shoe a citizen of the state of Washington?
It was not.
Was an International Shoe present in the state of Washington?
It was not incorporated there, but it did have sales representatives.
Okay. As far as the court is concerned in International Shoe, did the fact that International Shoe had salespeople in the state mean that the company itself was present in the state?
I believe they included that, yes.
Are you sure? Because if they're present in the state, isn't that Penoyer rule? In some sense.
Well, didn't they have an analysis that a corporation is more a fiction than anything else, and that only by the activities of a corporation can you know that it's present?
That's true. What I'm saying to you is that as far as you're concerned, did the court really conclude that International Shoe as a company is present in the state for purposes of personal jurisdiction? Because it seems to me, if you can satisfy yourself that the company is present there, whether fictional or otherwise, then the Penoyer rule still applies, because we know that if you are physically present in the state, right? Because let me give you an example. A company is and we haven't talked about this in detail yet, but we will. A company is deemed to be a citizen of a state under two circumstances. If the company is incorporated in the state, or if the company's headquarters are in the state. Right. On the other hand, the company may be deemed to be present in the state, albeit not a citizen of the state, because the company has certain facilities in the state. So what I'm trying to understand is, was International Shoe deemed to be present in the state of Washington? Yeah.
The court said that it basically rejected that you need presence for jurisdiction and introduced the living context.
Okay, so what is the rule in we know the rule in Penoyer is citizenship or presence equals jurisdiction. So what is the international rule? International rule, if you, yeah.
I think the term they use is minimum contacts.
What does that mean?
So that means that, using the case of the salespeople, I think that they also talked about like regular activities, and like they were doing substantial things with minimum contacts in a state. And then I don't remember exactly if this was the case where they talked about if you submit yourself to the benefits and the protections of the law within the state, then you also have to be ready to be sued within the state.
The court is throwing out a lot of terms, but it seems to me that you all are right. The court introduces the concept of minimum contacts. The court said it because it means that you have to engage in certain activities in the state. The court says if you engage in activities, then you presumably are enjoying certain benefits, etc. Minimum contact. Now, how much contact must there be for it to rise to the level of sufficiently minimum contact? Yes.
I think one of the terms they used was systematic and continuous.
So the contact have to be systematic and continuous, right? Okay. So, would you mind if I stay with you for a moment and help me understand how to reconcile that idea of systematic and continuous contact under International Shoe with McGee? Do you recall what the McGee is about?
Sorry?
Do you recall what McGee is about?
No, I'm just looking right now. So, in McGee, it's a situation between a California resident and a corporation that's not headquartered in California but in Florida.
Mm-hmm.
And so, at a certain point, the California resident dies. He names someone the beneficiary of his will, which is why he has a contract with the Florida company to begin with. The person tries to collect on behalf of Franklin. The company says no because they had no minimum contract in California besides this one single Franklin, this one single guy. And basically the court says that because of the long-arm statute, of California allows jurisdiction over non-residents, especially for this one because of how much communication there was between McGee and the life insurance company. So even though it wasn't as continuous and systematic as an International Shoe, which was 3 years of sales associates, they found that it has jurisdiction over the company because of the substantial connections.
Okay. So we have one case, which is International Shoe, where the company employs multiple salespeople, sells multiple units over multiple number of years, And the court says that, look, you've maintained a systematic and continuing relationship with the state, you've engaged in all these activities. But then you flip to McGee, and McGee involved a single insurance policy that the company sold to a single person in California, right? And when the company refuses to honor the policy at the person's death, the beneficiary of the policy tries to sue the company in California. Now let me ask, and I can ask you, anybody else can answer the question, had the company ever sold another policy other than that one policy in California? Did the company have any other client other than that one client in California? Had the company engaged in any activity other than that one policy in California? Then under what sort of conditions then can you possibly describe that behavior as continuous and systematic when it's a single policy? Yeah.
I think there was also another guideline that shaped the answer, which are like, I think it's in a different case. It's in Volkswagen v. Woodson.
Well, we're going to get to Volkswagen. But I just want to understand how you reconcile McGee with International Shoe. Because the whole point is to make the two cases make sense and to synthesize them. So if I were to purely put International Shoe together with McGee, right? Your colleague just told me that minimum contact is when you engage in activities in a state that is continuous and systematic. If I add McGee to International Shoe, how do I make the two of them make sense? Yes.
A state, one of the rulings in McGee is that a state can also have personal jurisdiction over a non-resident corporation if the state has a manifest interest in having jurisdiction over the case.
Well, presumably the state might always have an interest over the having jurisdiction of the state. Because I think you're right, though, that generally speaking, for both McGee and International Shoe, right, one of the reasons why the state has jurisdiction is because the state has an interest. In the case of International Shoe, the state wanted to make sure that the company paid that unemployment tax, right? In the case of McGee, the state presumably wanted to make sure that one of its residents fairly collected on the policy. So chances are that's a fairly sort of minimum test. I just assume, though, after International Shoe, continuous and systematic meant a fairly large number of contacts. And here there's only one. Yeah.
It says something about them developing a trend by doing the same thing in multiple states.
Meaning?
So since they were issuing this with like the nationalization of commerce, it says the tremendous growth in the amount of business conducted across state lines. Since they had done the same thing in multiple states, they developed a trend that gave California jurisdiction.
Okay, that's one possibility, yeah.
I think it says that there should be like, as long as they're substantially connected to the forum state.
Substantial connection, okay, yeah.
International Shoe says that the minimal contacts have to be such that it maintains the suit doesn't affect traditional notions of fair play and substantial justice. And since in McGee, the insurance company not only sent out a new certificate reissuing the life insurance, but they also collected life insurance payments, it does seem to be coherent with notions of fair play and substantial justice that they do have to pay out that life insurance.
So the International Shoe test, even though it's not a two-part test, says, look, your contacts have to be rise to a level of minimum contact, and they have to be such that somehow it doesn't seem unfair. Now, it's not really a test if you think about it that way, because it seems as if it's a bit circular. Right? So I'm going to ask you to sort of explain to me, if you don't mind, if you remember Hansen versus Denker, which also involved the sale of some sort of policy. So then how do I reconcile Hansen-Dekla with McGee and International Shoe?
Will you remind me of that?
Hansen-Dekla involved a company that, a bank, right, that had entered into a business with a resident of Pennsylvania, where the bank agreed to be the trustee, right, for that Pennsylvania resident, right? The Pennsylvania resident later on moved to Florida. And at their death, the estate tried to essentially sue the bank in Florida. The bank was located in Delaware, didn't have any business in Florida other than that trusty relationship the person had. And what I can tell you, and I'm sure that you all will agree, is that the outcome of the case is that, unlike McGee, there was no personal jurisdiction against the bank in Florida. So I'm trying to understand why. Because I know with a single policy in McGee, there was jurisdiction. There was also this single transaction, but no jurisdiction. What's the difference between the two?
It seems that the bank took on the responsibility while that Simpson was in Pennsylvania, whereas in McGee, they took on the responsibility of life insurance policy while Simpson was still in California.
Okay, so you're saying to me that I could have had jurisdiction over the bank in Pennsylvania?
I guess so.
Why not in Florida, though?
Well, maybe for whatever reasons that they had, they thought that they would be willing to take the risk of dealing with the bank in Pennsylvania. Maybe it was just more convenient reasons opposed to.
Well, let me ask this general question. The contract between the company and the client in McGee was entered in California, right? Where was the contract between the client and the bank in Henson? Yeah. And where was the client living at the time? So, where could you have gotten jurisdiction over the bank using the McGee reasoning? Why could you get jurisdiction over the bank in Delaware? I think it's simpler than that. I think you're absolutely right. I'm 100% certain that under every circumstance, I can get jurisdiction over that bank in Delaware. Why? Has nothing to do with the contract. It's simpler than that. Yes, sir.
Because that's where they're domiciled.
Yeah. The bank is always present in Delaware because the bank is a Delaware bank, right? So I think you're right. What is the second place I could have gotten jurisdiction over the bank? Yeah, go ahead.
Pennsylvania,
Why?
because according to the rationale, the Delaware Bank purposely availed themselves of the privilege of doing business in Pennsylvania because when they originally had the contact with Donner, she had been a resident of Pennsylvania.
Exactly. So presumably under Henson can be made to seem like McGee because as your colleague suggested in the back, right, it's not the number of the contact that matter. It's the fact that the McGee the insurance company maintained essentially a continuous relationship with that person over a number of years in California, knew they were in California, communicated with them in California, presumably sent bills to California, presumably corresponded in California. So it's not as if it came as a big surprise that at the end, the insurance company got sued in California, right? But contrast that with Henson. The company maintained a relationship with that client in Pennsylvania, corresponded with them in Pennsylvania, presumably sent bills or whatever it is in Pennsylvania. At some point, the person happened to move to Florida, right? And then suddenly, the bank gets sued in Florida. So then, what is the rule that we're supposed to take from, if you were to add international shoe to McGee and Henson? What is the rule? Yes, sir.
I think, like Aaron mentioned, the purposeful availment of doing business within the state would override not being president of the state.
What does purposeful availment mean in plain language?
Taking advantage of doing business with residents or under laws.
So presumably, right, you take advantage of the fact that you can do business in that state and you purposely, willingly, voluntarily engage in business with the state. Is that correct? Okay, so can we talk about Worldwide Volkswagen for a moment? Now we're going to come back to these cases as we go back to the chart. Somebody summarized the facts of Worldwide Vol. And in summarizing, I want to be very clear as to who the plaintiffs were as well as how many defendants originally were in the case. What happened in World War II? Yes.
So, and I may need clarification here, because Volkswagen is first, but the original parties to bringing the lawsuit were Harry and Kay Robinson.
Mm-hmm.
So, Harry and Kay Robinson bought a Volkswagen in New York, and they prepared to move to Arizona the next year. On their way to Arizona, they were struck by a car in Oklahoma, and in which the vehicle caught on fire and left them severely injured. The plaintiff, meaning in this case the two people in the vehicle, Harry and Kay Robinson. I'm sorry, let me take it back. They sued in Oklahoma State Court.
Yes.
Volkswagen especially appeared and argued that Oklahoma did not have any personal jurisdiction over them because they had no contacts with the state of Oklahoma.
Okay. So let's sort of separate the defendants for a moment, because when the plaintiffs get into an accident, they sued the manufacturer of the car, right? Which was an Audi. They basically sued also the importer of the car. They sued the distributor worldwide, and they sued the actual dealership, which was Horse. So they walk into a dealership. Where was the dealership located? Yes.
It was in New York.
So the dealership is in New York. Now, what argument? I'm not asking you to tell me the actual holding of the case, but I want you to think about this after International Shoe, after Henson, after McGee. What argument did the plaintiffs make? That is, the people who were in the accident. What argument did they make as to why it was fair to hold Seaway, the dealership that sold them the car, right, liable in an Oklahoma court? Yes.
Because it's a car and it's a vehicle that can move, like you can expect that the car will travel outside of the state.
You can expect it can travel outside of the boundary of the state. What was the exact phrase or term that they use and that the court is going to grapple with, which is almost like a synonym for expect? Yeah.
Foreseeable?
Exactly. They said, look, the point is foreseeability. Now, where did they get that concept of foreseeability?
Yeah, towards.
Like
negligence towards.
Almost, but with respect to the cases that we've been reading, notice that they're not trying to make new law. They're saying that the lesson you can learn from McGee was this, from International Shoe. Was it foreseeable to you as a company that you spent years selling shoes in the state, that you might get sued in the state? Right? With respect to McGee, they said, look, was it foreseeable for you to have maintained this years-long relationship with this person in California, that you might get sued in California? By contrast, in Henson, the argument was, well, is it really foreseeable that you maintain a relationship with somebody for years and years in Pennsylvania, and now you end up getting sued in Florida, right? Even though you had nothing to do with the person moving there. And the answer was no. So the argument then again was, is it foreseeable that you sell somebody a car, that they might drive the car out of state? Right? Why did the court say no? That's not good enough. Yeah.
Based off of what we were just discussing in previous cases, I would say they didn't basically avail themselves.
What does that mean?
They didn't have, I guess they didn't have sufficient contacts with the state. There was no other tie to the state outside of the fact that it's a car and it can be driven anywhere with us.
So, in terms of what was Volkswagen, right? When the court defines foreseeability, and I think you're right in saying that the argument that the plaintiffs made is that a car is something that by its nature can move from one place to another. And the court said that wasn't enough. How does the court define foreseeability?
It's about whether you can foresee that you'll be hailed into court suit in that.
So the foreseeability is not a mere theoretical foreseeability. It's whether or not, looking at the facts before us, you as a defendant, right, should not be too surprised, right? So let me ask this question, which I've asked others during office hours last week. Right? Supposing the facts of the case are exactly as they are now, everything remains the same except for one thing, right? When the couple begins their cross-country trip, right? As they're living in New York, they decide to take a route through New Jersey. They cross the Lincoln Tunnel, and as they get on the other side of the Lincoln Tunnel, the same accident happens. Is the result the same or different?
I think the result would be different. It's a lot more foreseeable for a New York car dealership to ascertain that people will drive through the Lincoln Tunnel into New Jersey.
Okay. Oh, I guess you disagree. Yes.
I mean, how Worldwide Volkswagen shouldn't have foreseen that this car that they just sold was gonna get into a car accident 5 minutes after it was sold.
Perhaps, but let's, for now, there's a reason I'm concentrating exclusively on the dealership, because the dealership makes everything clear. The dealership's role is not to sell the car, right? Okay. And we agree, according to the court's decision, that that dealership cannot be forced to go all the way to Oklahoma. Your colleague is suggesting that that dealership could be forced to go to New Jersey. Do we agree or disagree? Same facts. Nothing has changed other than the fact that they got hit in New Jersey rather than Oklahoma.
I think it's more reasonable because if you're weighing like also the burden on the defendant to travel there, going to New York to New Jersey is a lot less, and it's also much more foreseeable that someone from New York would be driving in New Jersey.
So you agree?
Yes, yes.
Okay, yes.
I have kind of a question in my response.
Okay.
Like in that sort of logic, the foreseeability is based on what can be expected or what's reasonable in terms of the burden. But I thought in the opinion, the court kind of stated that foreseeability in this situation is based on what the defendant's conduct in connection with the forum state make it reasonable that they can anticipate being prosecuted or sued there.
You're absolutely right.
No matter how reasonable or unreasonable the burden is, if their actual actions don't make it so that their connection to the state is substantial, then it would still be not foreseeable.
I cannot disagree with you. You're absolutely right. That's exactly what the court said. The court said the foreseeability that matters is one that is filtered through your own action, that you've undertaken voluntarily, so that you shouldn't be surprised if you end up getting sued. And presumably, whether it is burdensome or not, so long as you did it voluntarily and you shouldn't be surprised, then you're good to go. So what's your answer for me then in terms of New Jersey?
They shouldn't be sued in New Jersey. I think, yes.
Well, wouldn't you want to know some other facts then? Are you familiar with what New York and New Jersey, are you familiar with the...
Geographically speaking.
But also the way we will behave in terms of a market, right? Let me ask you this. What other tidbit did the court mention? Because I think you're on the right track. What other facts did the court mention about that dealership and what it did or did not do with respect to Oklahoma? There are a lot of facts that are mentioned in terms of trying to draw connections or lack thereof between Seaway and Oklahoma that perhaps you can extrapolate with respect to New Jersey. What do you think?
One was that they don't garner substantial revenue from sales to people who presumably are taking their vehicles to Oklahoma.
So let's stop there. With respect to New York and New Jersey, do you think it's likely that chances are Seaway made money from people from New Jersey?
Yes.
Okay. What are the facts, other than actual customers who buy cars, did the court mention between Oklahoma and Seaway and like that? Yeah.
The dealership was purposely advertising to people in New Jersey, New York, and Connecticut.
Exactly. So, number one, first of all, it's close proximity. Number two, you're probably getting your customers from New Jersey. Number three, chances are you are advertising toward New Jersey people saying, come, buy from me, right? So we agree that perhaps then, if you put all these facts together, it is foreseeable that you're going to get sued in New Jersey, not because the car moves, but because I think the rule that you announced is the heart of the case. That the point is what you yourself did to put yourself in contact with the state so that when you get sued there, when you're held into court there, you shouldn't act shocked. You shouldn't say, who, me? Yes, you. You did it. So therefore, you shouldn't be surprised. Are we in agreement? You disagree?
Yeah, I'm not disagreeing. So basically, them naming themselves Worldwide Volkswagen, them naming themselves Worldwide is getting them in trouble.
Not necessarily. And I think we're going to get to that point by the time we get to Osahi and McIntyre. So let's put a pin on that. The fact that they sell all over the place isn't itself determinative. Yeah.
So if the item in question was not a car, I bought with a portable van in a store in New York, walked or drove across the whatever, and then it explodes in my hand and breaks my hand off or whatever, then is that like, even though, because you just said because it's a car, it doesn't matter that a car moves, but it's the product.
Beautiful example. And I think you know the answer because then you have to go through the analysis. The analysis is what did that store that sued you to fan do to bring itself into contact with New Jersey? It's not you who went to New Jersey that matters. You'd have to tell me, and you can, it's your hypo, you can make it whatever you wanted to make it, right? Did that store do anything to bring itself into contact with New Jersey? Yes or no?
Is it enough that there's like suburbs of New York and New Jersey, and therefore like that you can expect that the people that are in New York, a lot of them probably live in New Jersey?
Absolutely. But let's go further. Suppose it's not New Jersey, it's Connecticut. But don't be, you see, you cannot allow yourself to basically be distracted by this sort of glittering lure of geography. You have to go back to her rule. Her rule is not that I don't care whether it's 5 or 10 or 50 miles. The key is what did you do to bring yourself in contact with New Jersey or Connecticut or Pennsylvania. Because then the only thing I would do is that I would keep giving you these stupid examples where I move the item further and further and further away from New York. I make it Pennsylvania. And you say, well, yeah, but that's a dumb example. You say, that's not the key. Geography isn't the key. The key is what she's saying. Did you purposely bring yourself in contact with the state so that you shouldn't be surprised? Now, there are many factors, the factors that your colleagues mentioned. The fact that I'm attracting customers from you, so my revenues come from you. I purposely do things to say, come see me because I have a great time. See what I mean? That's the key. The geography itself, I can make it further and further or closer and closer to you, but that's something the great factor. Yeah.
So it's basically saying that it can't just be like the plaintiff being able that it has to do something to like have some kind of relationship. It can't just be this like reliable.
I think you're absolutely right because the key is the defendant, and the reason why you're right is because of hindsight. Because remember, how did the bank become in contact, supposedly, with Florida at all in hindsight? Yeah.
It was just by virtue of the mere connection with the plaintiff.
Exactly. It wasn't an action that the defendant took. So faced with a situation where you're talking about minimum contact, you don't really think about the plaintiff. What you focus is the defendant. You focus on what the defendant has done. And you focus whether or not what the defendant has done on purpose or not. Right? Okay. So now then that's worldwide, right? And we're going to come back to worldwide in a moment. But for now, what I want you to do is to jump ahead and look at Keaton versus Hustler magazine, which is on page 124. Take a moment to sort of refresh your memory about Keaton versus Hustler magazine, and then someone tell me what happened in that case.
So this woman, Keaton, wants to sue for defamation of Hustler magazine. And she runs into this problem where in the majority of states, the statute of limitations for the thing that she wants to sue them about has already elapsed.
That's correct.
That is not, however, true of the state of New Hampshire, where Hustler magazine sells a pretty significant amount of magazines. Miss Keaton, though, has like sort of a more tenuous relationship to New Hampshire. There was like a mention, I don't remember what specifically it was, but like once she maybe was like an art manager for like one thing that maybe got published there or something. Like her connection to the foreign state is much less. So a district court dismisses her suit on the grounds that the plaintiff does not have significant enough contacts with the foreign state, which is like a new ripple. Previously, we've only talked about whether the foreign state has sufficient minimum contacts with the defendant. And then on appeal, that analysis that the plaintiff must sort of uphold the same standard gets reversed. You can purposely choose to avail yourself of the jurisdiction of the court, as long as that court has jurisdiction over.
Now, the key, and you're absolutely right, and the key to the analysis is to remember. When we ask ourselves whether or not a court may exercise jurisdiction over the defendant, right? As a constitutional matter, what fundamental concepts, right, are we really concerned about? Yeah. And what principle is the process designed to sort of effectuate it? What is the core, sort of almost moral concept that due process is designed to sort of establish? I mean, it's not even a legal concept. We're saying that, is it?
I think it's fundamentally about fairness.
It's about fairness, right? Fairness then is really about the defendant. Because if you're a plaintiff, why is it that we're not concerned about fairness for purposes of jurisdiction?
You've chosen to enter into this arrangement.
Yes, the plaintiff is choosing to sue in that particular form. So why do we care? The only thing we care about is the person who hasn't chosen to come to court, but is being compelled to go to court, right? That clears it. Okay, so let's go back then to this particular aspect of the chart, because we said that in a Penoyer universe, this analysis would be over. Since we're no longer living in a Penoyer universe, we've gone through this and we said, okay, it's not a citizen, the person is not present, so therefore we're here. What is the next question then you would ask yourself in this analysis? Yes, in the back.
Do they have sufficient minimum contacts with the state?
So, minimum contacts. I think you're right. That's what it is. So then how do I answer that? How do I capture what the meaning of that is with respect to a series of questions you would ask yourself in this flowchart? Yes?
Did that defendant conduct a business which in turn led to like making money?
Which basically translates into purposeful availment, right? And how do you know whether or not it's purposeful availment? Yes?
Is he utilizing the market, that is, he is trying to gain money or gain protection from the jurisdiction that he is in?
I think you're right. But let me suggest something to you in this chart. that in fact I've jumped the gun and misled you about the child. Because it seems to me there's a threshold question that you have to ask yourself that comes up in the cases almost indirect. The first question that I should ask, even before I worry about minimum contact, that applies to somebody who's not a resident, is not a citizen. Yes, sir. Well, consent is a good question, right? And we're going to get to consent in a couple of classes. But may I suggest to you, which is the reason I keep saying this chart that you're writing, you're going to keep rewriting it over and over again. Because the whole point of this analysis is that you're supposed to do it in a lazy way. You're supposed to basically get the easy answers first before you get to the hard ones. And consent is easy. So if consent is easy, where would you put consent? Even though it's not in the order in which I'm discussing the cases. You can either put it at the very top, or you could put it here. You could basically say, before you get to minimum contact, if you know you're not a citizen, you're not present, you can say, did you consent? I'm admitting to you that I haven't given you the cases about consent. If you look at the syllabus, you'll see them, right? But consent is what every one of you have done already in this room. Whenever you've checked the Apple Terms of Service, you've agreed to be sued somewhere in the West Coast. And by the way, if the answer is yes, you've consented, where do you go in the analysis next? Not the end. Remember, there's something you always need.
Notice.
You go back to notice. Notice is a prerequisite for everything, right? I know we haven't talked about it, but I'm trying to give you the structure of the analysis that the cases begin to click into place. So now, if in fact you consented, right, then I guess you go here, you go back to the notice analysis, and you follow it down the line. But if the answer is no, you haven't consented, then that's why we get to the minimum contact test. But I'm saying there is a particular thing, a particular tool you need in the specific instance where you have somebody who's not a citizen, who's not present, and hasn't consented. Simply in terms of an image, right? What is the concept? What is the state trying to do to reach that person? Yes?
We're talking about long-arm statutes?
Exactly. You need to have a long-arm statute. What does that mean as far as the cases are concerned? Yeah.
I think it means that a state can reach outside of the boundaries of its territory to basically pull someone else from their home state to bring
Now, here's the example I want you to think about. Go back to international shoe. Even if that phrase isn't exactly used, what kind of long-arm statute was there in international shoe, if at all? Yes?
Wasn't it the unemployment tax thing where it was like companies who do business here need to pay into the pot of unemployment funds?
Exactly. Sometimes, right, you have a long-arm statute that is very specific. The statute would say, if you do business in the state, right, then that statute authorizes. Now, let me ask you a question that I would like you to think about and perhaps look at the case. Was there a long-arm statute in worldwide Volkswagen? And if so, what was it? Your colleague is right. The specific long-arm statute in international shoe was very narrow. It was about if you do business in the state, the statute authorizes us to have jurisdiction over you for purposes of collecting taxes. I suggest to you there was a long-arm statute in worldwide. I'd like you to tell me what it was. Yes.
The accident was in Oklahoma and on Oklahoma roads, and that's basically state property.
Okay. But was that the actual statute? Yes.
There's a specific statute cited that you might bring cause of action they suffer some injury in the state by an act which haven't, or was resulted from an act that occurred outside the state by a business that has other persistent course of conduct, derives substantial revenue from goods used or consumed in that state.
Well, where are you reading from here?
The footnote on page 115.
Okay, go ahead. Now, go back and look at the paragraph before the intended paragraph. What kind of long-arm statute does this describe? Yes.
It says that it's to the constitutional limits available.
What does that mean?
So, to whatever extent the Constitution allows a state to have certain long-arm provisions, their statute matches that. So it's the widest scope constitutionally permissible.
Notice that as you read the cases, and I'd like you to think about this as you read with the cases, there are two kinds of long-arm statutes, generally speaking, that exist, right, with the state. One is what we've been talking about so far, where the state says, if you meet condition X, Y, and Z, you do business in the state, you do something that causes harm in the state, or what have you, or you need to pay taxes in the state, then long-arm statute reaches you. The other one is the so-called maximum long-arm statute, in which the state basically says, we're not going to define any behavior that you have to engage in, because we don't care. Our long-arm statute reaches as far as the Constitution allows. So essentially, the statutory analysis collapses into the constitutional. Does that make sense? Yeah.
Doesn't the Constitution go back to general jurisdictions, and you have to go through the same test?
Exactly. In other words, the statute says, our statute reaches as far as the Constitution says it is fair for us to reach. Because typically in an analysis of jurisdiction, the first thing that I have to do is to say to you, okay, is there a long-arm statute I can use against you? Well, if the long-arm statute says you have to have a contract in the state, and there is no contract between you and me inside the state, then unfortunately, I don't even get to the constitutional analysis. The long-arm statute is not long enough for me to reach you, right? But even if statutorily, the long-arm statute is long enough for me to reach you, because it says so, I still have to continue and say, okay, it's long enough to reach you, but does it meet the constitutional requirement of the process? The maximum statutes basically said, assume that it can always reach you, because I have no limits. The only limit is what the Constitution says there is. So you don't have to bother asking yourself whether or not there's a statute that reaches long enough. All you have to do is to do a constitutional analysis. Yes?
Do most states have like this blanket maximum thing? Because the two cases we read, the Hess one was about the cars, and that was like you have to get in the accident, and then the international shoe was about the specific unemployment. Like, is that a trend? Like, do a lot of states have maximum long-arm statutes?
I mean, it's hard to answer the question. Nowadays, yes. What happens in most jurisdictions is that they will do what Oklahoma does. They will basically say, look, there are three ways we can reach you. One is if you do X, one is if you do, second if you do Y, and then we can reach you if the Constitution says it is. So for all intents and purposes, it's the last one that controls, because it's the easiest thing to do.
Yeah. This is essentially though just the legislature just like punting their like duty of legislating and like delegating it to the court by basically saying like we're not even going to try to put any sort of legislation on this, and the court can just legislate this for us.
Yes, but what the legislature is saying is that why should we bother having some specific limits on what long arm is when whatever limits we put on long arm might get slapped back down because the court says it doesn't meet due process. If what we know is that due process is the line that we can cross, then we'll simply say our rule is that we're not going to cross that line. Because it's less work for everybody, right? Yeah.
Can you basically use, like the hypothetical you just gave, can you basically use Hess and Pulaski to do that? Because they have a long arm statute that allows them to sue in in another state, but they didn't violate due process because they forced, like you had to actually serve notice of suit to them in that state.
Well, let's back up and sort of separate the two. The notice thing is always present. What happened in Hess, and remember, Hess precedes the international shoe regime, right? A minimum contact, right? The analysis in Hess would be something like this. The long arm statute says that if you drive on our roads, you implicitly agree to subject yourself to jurisdiction. So we can either do two things. We can pretend as a fiction that what you've done is consented, but it's a fiction. We can say, look, we can say that the moment that you drive on our state road, you voluntarily taken action on that state road. And therefore, by taking action on that state road, it is enough, as far as we're concerned, for there to be minimum contact so as to subject you to jurisdiction. Now let's pretend that we're going to use the minimum contact test to analyze Hess, right? The first thing you would ask yourself is this, which is the problem. Would the fact that I entered into Pennsylvania, was in Pennsylvania for maybe 20 minutes, got into an accident in Pennsylvania within those 20 minutes, and then probably exited Pennsylvania, right? We all agree so far. And the long arm statute for Hess says that if I do anything in Pennsylvania that causes harm, then I am subject to long arm jurisdiction. So we're now in an international shoe regime. What's the analysis? Can Pennsylvania exercise jurisdiction over me consistent with the new analysis that we just talked about in international shoe? Now, the way I would do it is that I would say, okay, statutorily, is the statute long enough? Yes, because it says if I cause harm in the state, I did. Check. But the second question is what? I've already checked the statute box. The statute is long enough to reach me. What else do I have to ask myself? Yes, sir.
Is the statute consistent with due process?
Okay, so what's the analysis? Consistent with international shoe, Ensign, McGee, and Wellwan. Yeah.
Whether there were minimum contacts?
Okay. What else?
Purposefully availed yourself of the laws?
Did I?
By driving on the road and suppose in a sense.
Okay. Your colleagues next to told me, though, after international shoe and McGee, that the contacts are supposed to be consistent, not consistent, systematic and continuous. I was in the state for 15 minutes.
Definitely not then, yeah.
So I'm allowed to come into the state, cause whatever carnage I want, but because I wasn't there long enough, you can't sue me. Yeah.
You make the foreseeability argument that if you get in an accident, should you expect to be sued in that state?
That's the key. That's a rule. That's a rule. The rule is, what did I do? Did I do it willingly? And are the circumstances of what I did willingly such that it's not going to come as a big shock to me that I'm getting sued in the state? If you take what she said seriously, it doesn't matter whether I was in the state for 15 minutes. I took the action willingly. I purposely availed myself. Nobody forced me to do it. Right? The circumstances under which I took that action is such that it was foreseeable that my getting into an accident in Pennsylvania might get me sued in Pennsylvania. The fact that I was there for 15 minutes is simply me trying to sort of put a shiny mirror in front of your face, just like I'm trying to push the car beyond New Jersey, beyond Pennsylvania, because you see, it doesn't matter how far you go. It doesn't matter how long I've been there. The question is, did I do this purposely, willfully, And are the circumstances such that it shouldn't come as a surprise to me that I'm going to be in court in that state for what I did? Yes.
Question, is that why states put signs up on the roads when you enter a new state and you say like, welcome to ABC, so that they can say like, you knew where you were?
I would like to think so, but I don't think so. There would be a certain sort of poetic justice to it if that was the case, yeah. Yes, welcome to the moment.
Do you need both purposeful availment and disability to establish contact?
That's a fantastic question, and no one knows the answer because in some sense they mean the same thing. Personal availment means that the action cannot be the action of somebody else, it must be mine. But are there circumstances under which, right, that I can personally avail myself and yet not cause the foreseeability question? Can somebody give me an example, hypothetical, that I did something purposeful and yet it's not foreseeable that I'm going to get sued again?
And I think McIntyre, the facts of the case of McIntyre.
Well, McIntyre is a bit complicated, which we're going to get to after the break, because there's a whole matter of where McIntyre could be sued, right? Yeah.
If I'm chatting online with someone that's anonymous who lives in another state that I don't necessarily know, I am personally availing myself of talking to someone in another territory, but I don't necessarily foresee that I would in any way be subject to a suit.
But you didn't purposely avail yourself of anything because you didn't know the state under the hypothetical. I want you to give me an example of where I do something where I know I'm contacting a state and yet I don't cross the foreseeability line yet.
Keaton versus Hustler.
Keaton
versus Hustler.
How so?
Because even though you purposely avail yourself of the circulation of your newspaper in the state, you didn't expect her to sue from there.
Except Hustler got sued in New Hampshire.
Right. But why? Well, I couldn't foresee getting sued in New Hampshire. Yeah.
Well, the problem that Hustler magazine had is that Hustler magazine contacted New Hampshire. It had tons of magazines in the state. It sold tons of magazines, and the court said, surely you knew it was foreseeable that you might get sued there.
Maybe entering the product into the stream of commerce, and then ending up somewhere that you maybe not have direct ties with, but you know your product is prevalent in.
That's true, except it's a bit, we're going to get to the stream of commerce line. The question that your colleague raised, I'm using to surface something that we haven't talked about yet, but we've all assumed, right? In addition to long-arm jurisdiction, what category of jurisdiction are you really exercising over somebody in all the cases that we've talked about so far? Yeah. What does that mean?
It means that it's arising out of the actions or related to the actions of the defendant. It's not just like general when you just like live there or you're incorporated there. That's like your home, so you have jurisdiction.
I agree with the first part of your sentence, but not with the second part, and I'll tell you why in a moment. But I think you're correct. So far, we're talking about specific jurisdiction, and that's the key to the distinction that you raised. In other words, if I make contact with the state, I purposely avail myself of that contact. Right? But for foreseeability to kick in addition to the circumstances, it must be that the suit that I'm being dragged into court to answer for must actually relate to those contacts. Right? So let's think about Hustler magazine, because I think the example is correct. Right? Did you notice what exactly was Keaton suing Hustler for? Yeah.
Libel.
Because of what? What happened? What was she complaining about? What did Hustler do to her that was wrong? You know, the facts of the case don't explain it sort of explicitly, but you can sort of read between the lines. Yeah.
During the interview, she was trying to do some sexual stuff. While the interview was taking place.
The magazine is published all over the country, right? But as your colleague pointed out earlier, the problem is that she cannot sue the magazine a bunch of places, there's a statute limitation as well. But she files New Hampshire, and New Hampshire statute limitation is much more generous, so she goes there. But I'm asking, what exactly was she suing about? If the contact is based on the publication of Hustler magazine, yeah.
Could it possibly because they wrote libelous stuff about her in the couple of years that the magazine was printed, and then the magazine was then sold as a subscription to that state?
So essentially, Hustler purposely availed itself of contact with New Hampshire, and the suit arises out of that behavior, right? So it combines purposeful availment and foreseeability. But can you take the facts of Hustler magazine, Keaton, and change a couple of things for me so that it wouldn't be foreseeable even though the contact was purposeful availment? Yeah.
Maybe they had like several different publications that were compartmentalized regionally, and they committed libel against Miss Keaton in a publication that they only published in like Washington, California, but the one in New Hampshire didn't run that article, and so they purposefully availed themselves of selling this article in New Hampshire, but by some editing they like put something in New Hampshire about like a local
That's one
celebrity
possibility.
instead.
That's one possibility. Or think about it this way, supposing she wasn't suing them for libel. She has a dispute with Hustler for, say, employment discrimination, right? But the employment discrimination happened in an office in New York. The statute of limitation has run. She goes to New Hampshire and she wants to sue New Hampshire for employment discrimination. Except the employment discrimination didn't occur in New Hampshire. It occurred in New York. So has Hustler purposely availed itself of contact with New Hampshire? Yes. Is it foreseeable they would get sued in New Hampshire? Maybe. Is it foreseeable that it would get sued in New Hampshire for employment discrimination that occurred in New York? No. So foreseeability and purposeful availment are not always the same thing, right? Questions? Yes.
So what happens to the systematic and continuous like little wrinkle that does that just go away, or is it applied to more corporate defendants and not
Well, that's certainly something that we're going to end up talking about, particularly as we come back and we talk about Asai and McIntyre after the break. But the systematic and continuous doesn't disappear, but it's not simply a matter of counting heads. What the court is saying is that the systematic and continuous phrasing is more qualitative than quantitative. You still have to focus on the nature of the contact. And yes, every once in a while the contact might be. So let's take a 5-minute break. When we come back, we're going to talk about Burger King. Right? We're going to talk about Asai and McIntyre. It's 1:38, so let's assume it's 1:40. Let's come back at 1:45, please. came up before.
That's okay, because like the process is basically
Okay, it's 1:45. Why don't we come back? Let's wrap up the issue of purposive availment, etc., with Burger King before we move to Asahi and McIntyre. Okay? So, early on when we discussed about the cases, I asked folks to tell me the facts of the case. But after a while, I'll simply dispose of the facts myself because I want us to get to the heart of the discussion. So Burger King, okay? A gentleman enters into a franchise agreement with Burger King in which he agrees to, run a Burger King restaurant, I believe in Michigan. The basic structure is what you all know the franchise to be. The parent company, Burger King, owns the name, the trademark, and the franchise agreement essentially says that Burger King will supply you with X, Y, and Z supplies, you'll pay for them, they'll have a national campaign that will benefit you, etc., and you agree to a certain fee agreement with Burger King, right? What happened here is that the man is running the business in his place of residence. Burger King is incorporated and located in Florida, right? And at some point, pursuant to the contract, he travels a couple of times, right, to Florida to conduct some sort of trading. But for all intents and purposes, he is where he is. Right? At some point, he breaches the franchise agreement, and Burger King decides to sue him in Florida. Right? Now, what argument does he make as to why he should be subject to personal jurisdiction in Florida? I'm not asking yet about the outcome of the case, but why does he say that he shouldn't be sued in Florida? Yes, go ahead.
He's basically saying that he was at a disadvantage being the person that was a corporation that engaged in the contract and that he lacked fair notice and was called by this like element.
So one argument that he makes, among others, is the fact that you have this gigantic company with tons of resources, located its own court, and are trying to drag me all the way across the country to respond to this lawsuit, where the company has much more of an ability to defend itself or to conduct a lawsuit in its residence. What else does he argue as to why it shouldn't be subject? Yes, sir.
You mentioned how the franchise itself is in Michigan and they made their communications through Burger King's local office in Michigan, not with the Florida headquarters directly.
Saying that all the events that occurred mostly occurred in Michigan. Now let me ask you this question as a factual matter. Do you know, or did you notice, or did you detect whether or not Florida had a long-arm statue in Burger King? Did the court discuss it at all? Yes.
I actually have a question related to that, because I think it's within the contract between the franchise and the franchisee that all disputes are going to be settled in Florida law. And so I was wondering if that's technically some form of long-arm statute, because then, they can have franchisees all over the place, but they all, in signing the contract to be part of that franchise, agree to be held in a Florida court.
Well, a couple of things, right? A contract between two parties can settle a few things that we've talked about from the very beginning. The first thing the contract can do is that it can say, if you and I have a dispute, right? I'm Burger King and you're a franchisee. Whatever dispute we have is going to be settled according to Florida law. So that's a choice of law provision. The second thing the contract could do, and again, we've talked about this from the very start, is that the contract can say, if you and I have a dispute, that dispute, the lawsuit, is going to be brought in a Florida court, and you agree to subject yourself to the jurisdiction of the Florida court. Right? We agree on that. So my question factually is that, did the franchise agreement between the defendant and the plaintiff have Florida as the place where the lawsuit should be settled? Yes.
I believe court mentioned that Florida had a long-arm statute that said it extended to any person, whether or not they're a citizen, who breaches a contract in the state by failing to perform the acts of the contract that were required to perform there. So by them not following through on their payments for the contract, they breached the contract that was
So, what you've answered basically is the first question that I asked, and you're right. That's an example of a non-maximum, right? Long-arm jurisdiction says, if you enter into contract in a state, or with somebody in the state, and you breach the contract, then my long-arm statute, right, can reach you. That's Florida long-arm statute, and I think you're correct. So the second question I'm asking you, though, is that remember this chart, that the analysis is easy if you can settle it here. We don't have to bother about minimum contact, blah, 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 long-arm statute, etc., because it doesn't matter, because you consented to it. So my question to the class is this. Was there a consent provision in the contract between the franchisee and the franchisor? Yeah.
No, it just said Florida law. It didn't say that you would be sued in Florida.
Exactly. So it's important to draw a distinction between the choice of law and the jurisdictional provision. Because I promise you, if there was a jurisdictional provision in the franchise agreement, this case would not have ended up in the Supreme Court on that basis. And the Supreme Court wouldn't be wasting its time engaging in minimum contact analysis. Because one of the things that we'll talk about either Thursday or next week is that it is virtually impossible to undo a consent provision for jurisdiction. If you consent to jurisdiction, right, it doesn't matter whether you consent to jurisdiction at a place till the end of the earth. You consented. So the court is not going to worry about minimum contact. So there was no consent to jurisdiction in the agreement. There was a choice of law. Now the reason why it may be confusing is because the court uses the choice of law clause as a way to justify the minimum contact analysis. Right? So my question then is this. Why did the court say that Florida could properly exercise jurisdiction over the franchisor in Florida? Yes.
Because there were sufficient purposely directed activities of the defendant towards Florida.
How so? What exactly did the franchisor do to purposely direct themselves to Florida? Yeah. Give me a few examples.
He said his payments to Florida, and I think he signed a contract in Florida as well, and then he visited Florida several times for business activities.
Signed a contract in Florida. Sent his payment to Florida. Trade in Florida. What else?
No, that's a massive question.
Okay.
Is it enough that he just signed the contract in Florida? Because that makes the contract formed in Florida for the longer.
That's a fantastic question. In other words, you all are asking the sort of questions that shows you can teach this class if you want to. Because all you have to do is to basically do these sort of mind games in which you put some facts and you remove some facts. What you're saying to me, the question you just asked me is this. Would the outcome of this case have been the same if all he did was to sign the contract in Florida and you remove all the other facts? What's the answer?
I guess I'd argue yes.
Because
at that point because the choice of law provision is giving consent to be governed by Florida law.
Mm-hmm.
And Florida law would unambiguously say that since you formed the contract in Florida, they have jurisdiction over it. So
first of all, your analysis was what up until your last sentence. It seems to me you cannot say that the choice of law itself gives consent to jurisdiction. The choice of law is simply a factor in the minimum contact analysis. I agree with you. If you sign the contract in Florida, if while you're signing the contract in Florida, you notice it says it is governed by Florida law, it doesn't mean you're consenting to jurisdiction. There's a different issue. It means that maybe, to go to a point, it should be foreseeable to you might get sued in Florida if you break that Florida contract. But it's not because you consented to Florida. Consent is the easiest jurisdiction to check. It's the easiest box to check. Easiest box to check. The analysis that you're engaging into is based on. I'm sorry. Tell me your last name.
Me?
Yes.
My last name?
Yes.
Okusoku.
That's Okusoku.
You can call me Sydney though.
What I'm trying to say is that the analysis that you announced to us at the very beginning was this. Focus on A, whether or not you purposely did the thing, and B, whether or not you did under circumstances such that once you get sued, it is going to be foreseeable that you get sued there. If you sign a contract with somebody who lives in Florida, and it's basically say it's Florida law, you haven't consented to Florida, but you're coming close to purposeful availment, right? Yeah.
But I thought in this case the Florida long-arm statute says if you formed a contract in Florida, we get your, does that
Yes,
not
you're
count as
right.
consenting if you?
But continue the analysis for me. If you check that box, what have you satisfied yourself in the analysis?
If you check the consent box.
No. You're saying the Florida long-arm statute says, if you do this with respect to a contract, then I'm going to subject to jurisdiction. You're absolutely right. Is that enough for minimum contact analysis? Is that the only question you have to answer?
Not for minimum contact.
What other question do you have to answer?
Well, I
The long-arm statute of any jurisdiction is itself subject to the due process analysis. The fact that Florida says you can be subject to jurisdiction because you breach your contract in Florida, that's all well and good. But I still have to ask myself, but is it consistent with due process analysis? You may say to me that, well, yeah, it's easy because I can show you how it is, but you still have to do the analysis. Do you see the difference that I'm trying to make? Okay. So what else was the franchisee subject to jurisdiction in Florida? Anything else? Yes?
Ruiz was basically sending money to Burger King every month in Florida. So Ruiz was transacting with Burger King from his state to Florida. So that's continuous business.
So either way you maintain it, it seems to me what Burger King stands for is the proposition that, yes, you enter into a continuous business relationship with another party outside of your state. You maintain that relationship for a number of years. We're not going to be too concerned about the relative burden. In other words, if you think about Burger King, for all of the verbiage of Burger King, essentially all we're saying is that Burger King is really McGee at the end of the day. We're just expanding the text. It's a systematic, continuous relationship that the franchisor did on purpose, personal development, under circumstances that it shouldn't be surprised that if you break your agreement with Burger King, they might sue you in Florida, particularly when the contract was signed in Florida and is governed by Florida law. Yes?
Is there a reason why they didn't include that class of jurisdiction in that contract, and why they just said governed by Florida law and not governed by Florida jurisdiction?
I mean, at the time, I can tell you why that business made that decision. Nowadays, most businesses try to cover all their bases by putting both choice of law and jurisdictional clauses. But there are plenty of contracts that don't include jurisdictional clauses.
Advantageous in any way to just have law